Good morning, this is your Kelso Report for Tuesday, January 10th. I'm your host, Clark Kelso. Well, we begin today with a death penalty case from the California Supreme Court. Now, that court only rarely reverses a death penalty. So even when the court reverses only the penalty, it is worth a close look. Under applicable law, a prosecutor has the right to seat a death-qualified jury, which essentially means a jury the members of which are not unalterably opposed to the death penalty. The actual standard from the United States Supreme Court's decision in Wainwright v. Witt provides that a prospective juror may be challenged for cause based upon his or her views regarding capital punishment only if those views would prevent or substantially impair the performance of the juror's duties as defined by the court's instructions and the juror's oath. In the case before the California Supreme Court, People v. Pearson, one of the jurors essentially had vague and largely unformed views about the death penalty, and was therefore equivocal about the death penalty. However, when asked whether she could impose the death penalty, she unequivocally responded yes. Nevertheless, the trial court approved the prosecutor's request to excuse the juror for cause, reasoning that her equivocal responses about capital punishment made her unsuitable as a juror. The California Supreme Court reversed, holding that equivocal views regarding the death penalty in general do not make a juror unsuitable for service, when that juror clearly indicates that she could impose the death penalty if appropriate on the facts of a particular case. The state is entitled to jurors who will try conscientiously to follow the oath of service and the law in a death penalty case. The state is not entitled to jurors who enthusiastically embrace the death penalty. And so, California Supreme Court affirmed the conviction but remanded for resentencing because of other types of sentencing errors in calculating the sentence. Well, our next case from yesterday involves environmental law. The Sierra Club brought a petition attempting to compel the State Department of Parks and Recreation to amend its general development plan for the Oceano Dunes State Vehicular Recreational Area to ban off-highway vehicle recreation activities on certain property leased from the county of San Luis Obispo. The trial court granted the department's demurrer without leave to amend, and the Second District affirmed in Sierra Club v. California Department of Parks and Recreation. The problem for the Sierra Club was that the use of off-highway vehicles on the property was expressly approved by a permit issued back in 1982. And it was, of course, far too late for the Sierra Club to challenge that permit. And since there was no ongoing or planned development of the property, a suit to compel Parks and Rec to amend their plan was premature. The department has no ministerial duty, according to the court, to update or amend its plan simply because an interested person wants the plan to be amended. And that's it for today's Kelso Report. Have a great day in the law.